The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
You may be seated. I want to welcome everyone to the Fourth Circuit Court of Appeals this morning. We have three interesting cases, and Judge Agee and I in particular welcome our friend Judge Hudson, who's assisting us today. Madam Clerk, would you call the first case, please?
Well, ready to hear arguments in 22-1127, Bestwall LLC versus Official Committee of Asbestos Claimants. Ms. Ramsey.
Ms. Ramsey, good to have you with us.
Thank you, Your Honor. Good to be here. Good morning, and may it please the court. Natalie Ramsey of Robinson & Call on behalf of Appellant, the Official Committee of Asbestos Claimants. Mr. Herron and I will be splitting the argument this morning for our side. We would each ask the court to reserve 3 minutes for rebuttal.
Yes, ma'am.
Thank you. For the past 5 years, a nationwide injunction entered by the Bestwall Bankruptcy Court has prevented tens of thousands of cases from proceeding against 128 entities that are not in bankruptcy.
Now, what you say tens of thousands? One of these briefs said 64,000. What's the number as far as you know?
Your Honor, there were 64,000 cases that were pending against Georgia Pacific and Bestwall before the bankruptcy. Approximately 22,000 of those were active at the time of the filing. Since that time, of course, because of the nature of asbestos injury, there have been additional people who have been diagnosed with asbestos injury, and those individuals are also prevented from pursuing their rights because of this injunction.
But all of those claimants can file a claim in this bankruptcy.
That's correct, Your Honor, but that is not their only source of recovery for claims that are based upon old Georgia Pacific product. It was Georgia Pacific that engaged in the divisional merger that was responsible for the asbestos injury, and both of its successors, Bestwall and what's called New Georgia Pacific.
So before the bankruptcy, they had a claim against Georgia Pacific. Now they can make a claim against Bestwall. So who's left out?
So they can also make a claim against Georgia Pacific under successor liability theories and other theories. And those are the theories that
I thought Georgia Pacific was no more, and it was Bestwall and New GP or something.
New Georgia Pacific, they could make a claim against based on successor liability for Georgia Pacific. And those are the claims that are being...
Well, if their claim is processed in the Bestwall bankruptcy, what's the difference? Why do they have a different claim against New GP?
They have a different claim because it's also a successor in interest. And under the law, the claimants, the plaintiffs, are permitted to pursue their source of recovery from any entity that has liability. And New Georgia Pacific, the plaintiff's claim, also has liability.
But they have one claim. Your argument, I take it, is that they should be able to go after multiple joint tortfeasors.
That's correct. But there are multiple parties that are liable for that one
There's
claim.
only
There's
one
obviously
claim.
only one recovery. But the plaintiffs have the right to pursue multiple sources for reimbursement.
Right. Absent a bankruptcy, there's no problem with any of that argument. But now you have a bankruptcy.
That's correct. And the bankruptcy has an automatic stay, which we do not contest, prevents claimants from pursuing in litigation their claims against Bestwall. That automatic stay does not cover non-debtors like New Georgia Pacific. A bankruptcy court is a court of limited jurisdiction.
But your injunction here isn't a 362 injunction, it's a 105 injunction.
That's correct, Your Honor, and that is one of the reasons that we were contending that the court erred, was because it was entered under 105 without any tethering to any other statutory basis. as it had to be. 105 is not a roving equity power. 105 has to be tied to another substantive right in the code, and this injunction was not tied to such a right. And on that basis alone, we believe, because the court specifically said in its decision that it was not evaluating the merits of whether 362 applied, or it did not look to Section 524G, the other statutory section that was mentioned in the underlying adversary complaint, the court failed to enter a 105 injunction with proper authority.
And all we're here on is the injunction, correct?
That's correct, Your Honor. We are here solely talking about the exercise of an injunction over the entities that are not in bankruptcy. That's the issue for today.
Why don't you tell us a little bit about the jurisdictional issue, which I take it is your main issue?
That's correct, Your Honor. So we have 5 bases for asking the court to reverse. I'm going to address the first 3. Mr. Herron will address the second 2. The first is that the bankruptcy court based its jurisdiction on contracts that were designed by Georgia Pacific to create jurisdiction over non-debtors in Bestwall's bankruptcy case. The second is that even if it were permissible for Georgia Pacific to have created that jurisdiction, considered in context, the documents themselves do not support the exercise of related to jurisdiction. Third is the 105 argument that I was addressing before. Fourth, it's a
Right, but
collusive
the
effort.
related to or arising out of jurisdiction, that's a separate issue than what the merits would be on confirmation of the plan.
That's correct, Your Honor. Jurisdiction is a fundamental issue, and subject matter jurisdiction, of course, is necessary for the court to act at
Right,
all.
Right. Well, I have to say, reading through your briefs, it seemed like to me that a lot of the issues you raised tended to be more issues that would come up on confirmation of the plan as opposed to a preliminary injunction at this stage.
Your Honor, our contention is the bankruptcy court did not have jurisdiction in the first instance to enter this injunction. It is clear that there are issues that the parties are raising on our side regarding the propriety of this bankruptcy case and regarding whether or not there will ever be a confirmable plan. Those are not the issues that we're here on today. Today we're on 2 fairly discrete issues. One is subject matter jurisdiction, and the second is whether, even if the court had jurisdiction, the injunction was entered properly. Turning to our first argument, Georgia Pacific created the contract terms that the debtor then used to argue to the bankruptcy court that it had jurisdiction over the plaintiff's claims against Georgia Pacific. The 2 documents that the bankruptcy court relied on, the secondment agreement and the plan of divisional merger, include provisions that were crafted to look like they were customary and normal in asbestos bankruptcy cases, and they create relationships that are designed to give the artificial appearance that they would support related to jurisdiction. But these documents were prepared in connection with a plan to have Bestwall file for bankruptcy, and Bestwall did that 94 days after its creation. The fact that the bankruptcy court relied on those documents, which were, number 1, developed in anticipation of the bankruptcy, number 2,
Right. Isn't there a threshold issue that you can look at even before you get to that point? Because the standard seems to be fairly relaxed at this stage, and that is whether the outcome of another proceeding, all these claims against GP or some other parties, could have any effect on the estate in the bankruptcy, which would seem to be axiomatic, because if you're litigating in state court in Wyoming, the same claim that would be before the bankruptcy court in the Bestwall proceeding, that would have to have some effect on it. So isn't there a nexus there for jurisdiction, at least on the related to prong, that's independent of these arguments on the contracts?
No, Your Honor, there is not, because
All right, why not?
Because related to jurisdiction, even though the standard has been broadly stated, if properly analyzed, looking at the case law, it really comes down to a question of whether there is a financial impact on the debtor. And here, under the documents that were assigned to Bestwall, there is a funding agreement. That funding agreement is an absolute, unconditional, non-recourse obligation to provide all of the money necessary to Bestwall for all of its administrative costs in connection with the bankruptcy and for anything it needs, everything it needs, in order to confirm a plan and to create a 524G
So you
trust.
say there's no financial impact on Bestwall?
There is absolutely no financial impact on
Because everything runs
Bestwall.
in a circle.
It's a big circle, because even under the funding agreement provides that Georgia Pacific can be called on under the funding agreement to in fact pay the indemnity obligation that Bestwall purportedly owes to Georgia Pacific for any liability. It's entirely circular. And in this instance, Bestwall argued, and the bankruptcy court accepted, that Georgia Pacific has the financial wherewithal to pay 100% of that liability. In addition, looking at the funding agreement, it is not conditioned on either a preliminary or a permanent injunction. So there is no circumstance under which it can harm financially the other creditors for
So
one creditor.
In your view of the case, you would say that new GP would also have to enter into bankruptcy before there would be related to jurisdiction?
They would have the benefit of an automatic stay if they filed for bankruptcy, and there would not need to be a question of exercise of jurisdiction. An automatic stay for the debtor is written into the bankruptcy code. It is not written into any other provisions. In fact, even 524G does not have, as part of its ability to obtain a permanent injunction, any provision for a preliminary injunction, even though it was modeled on the John Mansfield case where there was a preliminary injunction. So clearly the design of that statute is the bankruptcy court still must make a determination of related to jurisdiction and propriety to enter the injunction before it provides a preliminary injunction. Here, the bankruptcy court did not do that properly. Here, the bankruptcy court entered an injunction, again, under Section 105, but before you even get to authority to enter the injunction and whether the injunction was improvidently entered, there's a problem with the related to jurisdiction, because the bankruptcy court relied on the secondment agreement, and on its face, the secondment agreement does not permit the Georgia Pacific to call the seconded employees back. The seconded personnel are 100% obligated to Bestwall, and it is Bestwall's unilateral decision whether or not to excuse those employees. So there could be no distraction if Bestwall says no. With respect to the purported indemnification obligation owing from Bestwall to Georgia Pacific, as I've said, it's entirely circular. And the third basis that the court relied on, a purpose affecting the purpose of the bankruptcy, is a standard that does not exist under the case law. And in analogous circumstances where courts have looked at that type of argument in the 11th Circuit and the 5th Circuit in connection with tax cases, the courts there, the 11th Circuit and the 5th Circuit, and then the 3rd Circuit in combustion engineering, have all determined that the boundaries of bankruptcy jurisdiction can't be extended to facilitate a particular plan of reorganization.
They're arguing also arising in jurisdiction.
Well, Your Honor, with respect to arising in jurisdiction, there are really...
Let me ask you this.
Yes.
Can we reach that question since the district court, the bankruptcy court, and well, neither addressed it?
Neither did address it, Your Honor. Because it's subject matter jurisdiction, this court probably could make a determination about that, but
We have an obligation to look at jurisdiction.
But we do not believe that the arising in jurisdiction argument is well-founded. And first of all, a claim arises in a bankruptcy case is based upon no existence of that claim outside of bankruptcy. And so our first position would be the litigation between the plaintiffs and Georgia Pacific and the other non-debtors arose outside of a bankruptcy. But if you look at it in the context of a use of Section 105, the 105 would have no limiting principle. If the debtor is right about this, then just filing a bankruptcy would give a bankruptcy court nationwide incredible jurisdictional reach for anything that a debtor wanted to do, and that's
This is a
simply not the
nationwide
law.
injunction that is entered here.
I'm sorry?
This is a nationwide injunction.
It is a nationwide injunction that is entered here, and it is
As to state
extraordinary.
and federal courts both.
That's correct, Your Honor. And over tens of thousands of cases where there is a
But
completely.
why would you say it gives the debtor the right to do anything they want to? I mean, it's not unusual in bankruptcy for the bankruptcy court to center all of the claims that relate to the claims that are presented by debtors for creditors in the bankruptcy to be adjudicated in the bankruptcy. That's the whole point of it. So I'm not sure what other than that circumstance would occur here.
So, Your Honor, again, with respect to the bankruptcy's jurisdiction over the claims at issue and the ability of Bestwall to pursue a reorganization, those are not issues that we are contesting today. What we are saying today is that is separate. Those
Right, but what
panoply
you're
of rights are
contesting-
separate from
wait a
related to.
minute. What you're contesting is the exact same claim that's going to appear in the bankruptcy, conducted in all the other 50 states and other places. So you've got exactly the same claim in two spots. One course in the bankruptcy court, one course hither, thither, and yon. So these claims that are adjudicated outside of the bankruptcy, it would seem to me, would have to affect what transpires in the bankruptcy.
Your Honor, but the key with respect, and of course that statement broadly is true, but that is not the issue unrelated to jurisdiction. It's analogous, we believe, to the fact that in a bankruptcy case, someone can pursue a right against a guarantor. That action is typically not stayed. It's the same litigation, but there's another party that has liability for that, and that claim can be pursued. Similarly, asbestos claimants often have claims against more than one asbestos defendant. There are no stays for their actions against other asbestos defendants. If they're in a joint and several liability state and they pursue a claim against asbestos defendant X and asbestos defendant X pays their claim, similarly, it would broadly affect whether they had a claim in the bankruptcy
Right, but
case.
again, why isn't that something that comes up in the course of confirming the plan?
Because right now, the debtor has asked for there to be an injunction against those claims, and those claimants have rights that are material, that they're being held back from prosecuting against entities that have the financial wherewithal to pay them. And the fact that they no longer are claims in the bankruptcy estate does not affect, hypothetically in this hypothetical, that it doesn't affect the financial ability of the debtor to carry forward in its bankruptcy case and to propose a plan. And that's the crucial determination, as we believe the court correctly decided recently in the Arrow case, the bankruptcy court for the Southern District of Indiana, when it decided that, in connection with the 3M combat litigation, that there was no functional impairment on the debtor by this continued litigation against non-debtors in very similar facts.
Thank you very much. You've saved some time.
Thank you, Your Honor.
And Mr. Herron? Good to have you with us, Mr. Herron.
Thank you, Judge King. Good morning, Judge King, Judge Agee, Judge Hudson. May it please the court. My name is Ed Herron. I'm here on behalf of Appellant Sander Esserman in his capacity as the court-appointed future claimants representative. Your Honor, I'd also like to reserve 3 minutes for rebuttal. Your Honor, absent from the bankruptcy court's analysis is any limiting principle. I'd like to discuss two. One that's found in Section 28 U.S.C. Section 1359. The other is in 524G itself. Your Honor, 1359 prohibits the improper manufacturing of subject matter jurisdiction, and the bankruptcy court failed to consider this limitation. If federal jurisdiction could be created by assignments of this kind, which are easy to arrange and involve few disadvantages for the assignor, then a vast quantity of ordinary contract and tort litigation could be channeled into the federal courts at the will of one of the parties. Such manufacture of federal jurisdiction was the very thing which Congress intended to prevent when it enacted Section 1359. Your Honors, this is a quote from...
They say that only applies in diversity cases.
That's what they say, Your Honor, but that's not what the statute says. The statute...
That's not what says?
The statute is not limited to diversity, and they cite no case for that proposition. Your Honor, the quote I just read was from the Supreme Court 1969 decision in Kramer versus Mills, where, interestingly, they rejected the notion that the legality of a transaction under Texas state law was relevant for the purpose of evaluating the validity of federal jurisdiction. Under 1359, a district court shall not have jurisdiction of a civil action in which any party, by assignment or otherwise, has been improperly or collusively made or invoked or joined to invoke the jurisdiction of the court.
So they can't manufacture jurisdiction.
That's exactly what happened.
That's what it says.
That's what it
In
says.
any civil action.
Right. And the adversary proceeding
Is a
from which...
bankruptcy proceeding a civil action?
Well, this one is, Your Honor. The bankruptcy court issued the preliminary injunction after the debtor filed an adversary proceeding. An adversary proceeding is a civil action. Obviously, the bankruptcy court is a unit of the district court. And it was through that civil action that Bestwall obtained the preliminary injunction. And the bankruptcy court never considered whether Bestwall was improperly or collusively made. Absent that finding that Georgia Pacific created Bestwall for a proper business purpose, the bankruptcy court's exercise of jurisdiction over Bestwall's civil action is inappropriate. And of course, whether or not Georgia Pacific's corporate restructuring is valid under Texas law is beside the point. Again, that's Kramer versus Caribbean Mills, but this court endorsed that proposition in the Bishop case, which then cited the Lester v. McFadden case. And because this is a transaction between affiliates, Georgia Pacific created Bestwall in a boardroom and then filed documents with the Texas Secretary of State. It's subject to heightened scrutiny. But the bankruptcy court didn't even need to apply heightened scrutiny because Bestwall itself admitted that the purpose of this transaction was to manufacture jurisdiction. In its own complaint, it said the purpose of the 2017 restructuring was to seek a resolution of Georgia Pacific's asbestos claims under Section 524G. We believe this basis, the court's failure to apply 1359 in the face of this admission, is a basis for reversal. And then the inquiry could end there. But to the extent the court wants to evaluate the basis of the injunction itself, there are limiting principles found in Section 524G. 524G limits the instances when third-party non-debtors can obtain injunctive relief. And, Your Honor, this case is different from all the 524G cases which have preceded it. A key difference is here it's Georgia Pacific rather than the debtor Bestwall who manufactured and sold asbestos-containing products. And, of course, they did it 40 years ago. We dispute whether Georgia Pacific can use Bestwall's bankruptcy to obtain a permanent injunction under 524G for itself on these facts. And the Supreme Court and this court have repeatedly held that success on the merits of the action need to be shown to be by a clear showing and a likelihood of success. Here, the bankruptcy court did not apply the clear showing.
Talking about the Winter principles?
I'm applying Winter and Real Truth, and I note that Your Honor and Judge Agee agreed on these principles in the Henderson NLRB case. It requires a clear showing on each of the four factors, and it goes to the likelihood of success on the merits of the relief sought in the complaint, which is an injunction, not a successful reorganization. Here, Bestwall has no employees, it has no operations. The showing of a successful reorganization of Bestwall for purposes of a preliminary injunction is besides the point. And in any event,
Some cases that say that is the point on the first Winter principle in bankruptcy.
Well, Your Honor, I believe it's but I believe this court has said in the Microsoft case that when you enter a preliminary injunction, you look at the success of the ultimate relief. And here, it's the permanent injunction they're seeking. If the permanent injunction wasn't the central facet of this case, they wouldn't have required, their whole premise of obtaining a preliminary injunction for Georgia Pacific is because they want to wrap everything up into the bankruptcy. The injunction here, the permanent injunction available only under 524G, is why Georgia Pacific created Best Wall and then put
Right,
Best
but
Wall into
here
bankruptcy.
you just have a preliminary injunction here, this is not a proceeding for a permanent injunction.
Your Honor, of course, you're correct on the facts, but I think Your Honor has previously noted that a preliminary injunction sometimes can be more damaging than a permanent injunction if at the end of the day, the party who's obtained the preliminary injunction doesn't succeed on the merits and get the permanent relief which it's seeking. Here we believe the bankruptcy court applied the wrong standard to the wrong issue. Realistic possibility to a successful reorganization rather than a clear showing that Georgia Pacific and 127 other co-defendants who are protected by the preliminary injunction, whether all of them ultimately would qualify for relief under 524G and obtain a permanent injunction. Thank you, Your Honors.
Thank you. Mr. Francisco,
Judge King, and may it please the court, Noel Francisco for Best Wall.
good to have you with us, sir.
Thank you, Your Honor. It's good to be here. Judge Agee, as you were getting at, this case isn't really an attack on the bankruptcy court's jurisdiction. It's really an attack on the validity of the bankruptcy itself. But as appellants concede, that issue isn't before you. And given that concession, this is a very straightforward application of A.H. Robbins. The whole point of A.H. Robbins is to say that a bankruptcy court can put a temporary pause on claims against third parties if they're tantamount to claims against the debtor itself. Well, here, the claims aren't just tantamount to claims against Best Wall. They are literally the exact same claims. And if I could just quote the bankruptcy court's summary of it, which I think here is undisputed. The claims...
In the course of doing that, Mr. Francisco, our opposing counsel makes the argument that, as a principle, all that would be correct, but they say that this is sort of a charade, that the money just kind of goes in a circle, and it's simply a means for part of old Georgia Pacific to stay out of bankruptcy.
Sure.
So if you could respond to that argument and why that doesn't defeat at least related to jurisdiction.
Absolutely, Your Honor, and there are basically two responses. The first is that it doesn't really matter, their reliance on the funding agreement and the indemnification, because as the district court made clear, there's relating to jurisdiction wholly apart from the funding agreement for two basic reasons. The first is, and the standard that this court announced is, can the other proceedings that we're seeking to stay have any conceivable effect on Best Wall's rights, liabilities, options, freedom of conduct, either positively or negatively? I think that's almost a direct quote out of H. Robbins as to what the standard is. Here, the other proceedings can obviously have an impact on Best Wall's liabilities. The whole point of this bankruptcy is to resolve those liabilities under a 524G
But
trust.
anything that Best Wall pays out, they get it back from
Well, Your Honor, I think that's wrong, but I also
Georgia
think...
Pacific.
Yeah.
Well, that's what the agreement says.
Well, I'll get to that. I think it's wrong, but for purposes of my first part of answering Judge Agee's question, it doesn't matter. Because even if that were right, under the A.H. Robbins test, it has a direct impact on Best Wall's
But if
liabilities.
they get it back, whatever they spend, There's no impact.
Well, Your Honor, the standard under H. Robbins is, does it have an impact on those liabilities either positively or negatively? The whole idea of
what they're saying, it doesn't have any impact. It
Well,
goes
it
in a
does.
circle.
It
They pay
does.
it out, they get it back. They pay
It
it
does.
out, they get it back.
It does. They're wrong on that. But the whole idea of the type of temporary pause is that you have two places where you question the validity of a bankruptcy. You question it at the front end on the motion to dismiss, and you can question it on the back end in the plan confirmation process. In the middle, which is where we are now, the whole idea is you've got a concededly valid bankruptcy, and you're creating essentially a bubble around it to give it a chance to accomplish its purpose. So you're beyond questioning the purpose of the bankruptcy proceeding, and you're simply saying,
They're sort of saying that Georgia Pacific's not in the bankruptcy, but they're getting the benefit of it.
right, but what we're saying is that for purposes of this appeal, we've got a concededly valid bankruptcy in Best Wall. And the question is, are we going to give Best Wall a chance to succeed on that concededly valid bankruptcy? But I'll also tell you why they're wrong on the funding agreement, Your Honor. It's because it isn't entirely circular. If you look at the language of the funding agreement, it is crystal clear that we cannot turn to the funding agreement until first we exhaust any cash distributions that we get from operating subsidiaries to pay for the cost of the bankruptcy, and second, until we exhaust all of our assets to pay for the 524G trust. And the money that we then get from New GP through the funding agreement never fills in that hole. That hole is gone, and any funding is in addition to it. So they're wrong on that, but respectfully, as the district court found, I don't even think it matters, because first, it has a direct impact on Best Wall's liabilities, and secondly, this is the other point I was going to make in response to Judge Agee, Best Wall's employees, and this is their secondment agreement argument, Best Wall's employees have no choice but to spend their time and attention attending to the claims against New GP precisely because they are the exact same claims against Best Wall. Because they're the same claims against Best Wall, that means if those claims are litigated in the tort system against New GP, they'll create issue preclusion problems that will then affect Best Wall when Best Wall is litigating similar issues in the tort system, and they'll create evidence that can be used against Best Wall both in the tort system as well as in the claims estimation process that's part of the bankruptcy process itself. So those reasons, the liability, the distraction to Best Wall's employees, and the direct impact that litigation against New GP will have on Best Wall, those are three reasons why there's clearly a conceivable effect on Best Wall's rights, liabilities, options, or freedom of action, either positively or negatively, and that's wholly apart from indemnification and funding and the allegedly circular nature of the funding agreement and all of that. You never even have to touch that, but Judge King, for the reasons I've explained, I think they're wrong on that too. There's also a rising in jurisdiction here, and none of anything we've been talking about has anything to do with a rising in jurisdiction.
Nobody, the other courts, two other courts, bankruptcy court and district court, didn't address that.
Two responses, Your Honor. First, the district court did. It didn't rest its decision on that, but in footnote 3 of the district court's decision, he does explain why there would be a rising in jurisdiction. Secondly, it's a jurisdictional issue, so you can reach it yourself. And third, you can also affirm on any alternative ground that's properly presented, which this is. The test for arising in jurisdiction.
Well, before you get into the arising in, if we assume, just for argument, that you prevailed today on related to jurisdiction, would there be any barrier to the plaintiffs here at confirmation of the plan to raise the same arguments they're raising now as to the inadequacy of the plan?
So, Your Honor, I want to be careful about what I say because I don't know for sure of the answer. But as I stand here today, I don't think there would be a barrier to raising those arguments. But again, because I don't know, I don't want to commit to that answer.
But in the interim, these 64,000 claimants would not be able to pursue their claims
There would be
in the state and federal courts of this country.
There are 2 points, Your Honor. Yes, there'd be a temporary pause, but the second
It's
point
been a 5-year pause, and a lot of these people are sick.
Your Honor, when we filed our bankruptcy petition in 2017, of the 64,000 claims pending at the time, 75% of them had already been pending for 10 years or more. 55% of them had been pending for 15 years or more. It reflects the fact that the tort system doesn't deal particularly well when it comes to asbestos liability. That's precisely why Congress passed 524G to create a more equitable system.
How many courts are impacted by this injunction?
Your Honor, I'm not sure of the number of respect to that, but it's the exact same number of courts that are impacted by the automatic stay
It would be
as
the
it
trial
applies to Best
courts
Wall.
around the country. How would it be the exact same?
Because they're the exact same claims. What they've done is they've taken the...
You're saying the automatic stay definition is identical to the injunction definition of claimants?
What I'm saying is that the claims covered by the automatic stay as to Best Wall are literally the exact same claims that they are asserting against New GP by virtue of the restructuring.
Why'd you need this injunction if you had an automatic stay?
Because since they can't sue Bestwall, what they've done under the restructuring, all of the liability is assigned to Bestwall.
You asked the judge to say that the automatic stay covered all this, and in her opinion here, at the end of it, she says she's not addressing the automatic stay question.
Well, and Your Honor, that's because what we put before the bankruptcy court judge and the district court judge.
Talking about the bankruptcy court.
Yeah, where all of the reasons.
You said that the automatic stay took care of it, and well, if it does take care of it, you don't need any of this.
No, we asked her for a declaratory
If you don't
judgment.
take care of it, this thing is moot.
What we asked her for, Your Honor, was a declaratory judgment making clear that the automatic stay applied, and she held that she didn't have to get to that issue because there were multiple other reasons for entering the exact same stay. That's what makes this such an easy case under A.H. Robbins.
But you're saying that you already had a stay,
No, Your Honor,
and that
I'm
this
not.
is meaningless.
I'm saying that
on footnote 3 on page 2 of the judge's opinion, she defines or recites the definition of the, quote, best wall of asbestos claims. Do you subscribe to that definition also?
Yes, Your Honor. My point, though, is that the automatic stay, by definition, applies to Bestwall. What they are trying to do here is do an end run around that automatic stay by filing the exact same claims that they cannot file against Bestwall against Bestwall's affiliates, New GP and others. And what A.H. Robbins makes clear is that there are multiple ways for you to prevent that type of situation. One way is one of the ways we asked the bankruptcy court to proceed under, which is to declare that this is effectively an application of 362A itself. Another way is to say that it's under the court's relating to jurisdiction and the temporary stay is necessary and appropriate to furthering the bankruptcy proceeding. And yet a third way is to find that this is a proceeding that arises in a Chapter 11 case. All of those ways are simply different ways of getting at the same exact thing. They can't do an end run around the automatic stay by filing the exact same claims against Bestwall's affiliates that they're barred from filing against Bestwall itself. And so if I could turn to arising in jurisdiction, it doesn't involve any of the funding agreement or the alleged circular nature of it or anything else.
Well, you use the term Bestwall affiliates, but a lot of these claims are not against an affiliate, as you would understand that in corporate law, as I understand it. They're simply against joint tortfeasors, alleged joint tortfeasors.
Yeah, what I mean to say when I say affiliates is these are all part of the same larger corporate family, and more specifically, by virtue of the restructuring.
That's the Georgia Pacific corporate family.
The Koch Georgia Pacific larger corporate family. And what I mean to say is by virtue of the restructuring, the liability for all of those claims was vested in Bestwall and not in any of these other corporations. So what they're doing is because they can't sue Bestwall for those claims, they're filing the exact same claims against these other organizations, as my friend on the other side conceded, under some sort of theory of successor liability. Well, it just reflects the fact that what they're trying to do is assert liability that belongs to Bestwall against these other affiliates. And I'll go back to my general point about A.H. Robbins. Remember, there's a point at the beginning and the end of a bankruptcy case where you can talk about whether this bankruptcy was filed in good faith. When you're where we are now in the middle of a case, the whole point of this protective stay is to say we're going to pause things because we've got a bankruptcy that we're going to assume for the sake of argument is valid. Its purpose is to resolve these tens of thousands of claims in a 524G trust, and we want to give it at least a chance to succeed. That's why we create this bubble around it, to give the parties a chance to successfully resolve these 64,000 plus current claims, plus an untold number of future claims under a 524G trust. And Judge King, these claims had been languishing in the tort system for decades. Under a 524G trust, they have a chance to succeed. Under our plan, they would all get paid 100 cents on the dollar For every valid claim, they get paid more quickly than they do in the tort system.
Value of the things that have to be determined by a trial or something.
Well, Your Honor, and we've got some of the most sophisticated plaintiffs' lawyers on the other side, and that goes to the other two protections that are in 524G.
But they can't go to trial.
We cannot move forward, Your Honor, on any of this unless 75% of them agree to it. That's right in 524G itself. We cannot move forward on any of this until the district court and the bankruptcy court both approve of it as fair and equitable, and they also get a future claims representative, my friend on the other side, to represent the future claimant's interests. That gives us an enormous incentive to put forward a package that 75% plus of them are going to agree to. Because if we don't put forward a generous package that they agree to, we're right back into the soup that we're trying to avoid by virtue of this 524G trust. And towards that end, we have already committed $1 billion to a qualified trust that will go to funding any 524G plan. So with all respect, these 64,000 claims have a lot better chance of getting paid off soon under the 524G trust bankruptcy process than they do under the tort system. None of this, with all due respect, has anything to do with the jurisdictional issue that's before you. Here, the jurisdictional issue before you is a straightforward application of A.H. Robbins. And turning to arising in jurisdiction, separate from relating to, separate from 324A, arising in jurisdiction, the test that this court announced in Bergstrom is, could the proceeding have any existence outside of the bankruptcy process? Here, the sole purpose of the temporary stay is to prevent them from doing an end run around the automatics.
If you have the related to jurisdiction or whatever it's called, why do you all keep wanting us to move over to the arising in jurisdiction?
Well, Your Honor, if the three of you are prepared to tell me that I have relating to jurisdiction, then I won't move on to arising in
No, but
jurisdiction.
you actually started out, I think your brief led off with the arising in jurisdiction.
We were simply laying out all of the different bases for jurisdiction. Like I said, if the court is with me on relating to, I don't really care
No, I'm just-
whether you get to arising
I was
in.
just,
On
I noticed that.
yeah.
I didn't come over on the pickle boat.
I think one of the reasons is that arising in jurisdiction is you don't have to get into the funding agreement.
You thought that was easier.
Huh?
But we got a case or somewhere that says that relates to administrative matters within the bankruptcy.
Your Honor, I would put
Arising in.
I would put you right to the plain text of the statute itself. The plain text of the statute itself, and this is 1334B, the court has jurisdiction over all civil proceedings arising in cases under Title 11. There's no limitation to administrative matters, and this court has never so held. It's simply recognized that administrative matters are the types of things that arise in bankruptcy court cases. Here, we're simply seeking an end run around the 362A automatic stay. It lasts only for the duration of the bankruptcy proceeding
But if
itself.
you have an automatic stay that covers all this, which is what you said, you don't need any of this.
Well, Your Honor, again,
All these proceedings
if you are prepared and the panel is prepared to tell me that 362A automatically applies to the claims against New GP and the other affiliated organizations, I'm fine with that. But I want to make sure that if you're not prepared to go that far, there are
bankruptcy
other,
court didn't address that in her opinion here.
because the bankruptcy court.
You all said we have an automatic stay, and that covers this, and she says, I don't have to address this. I'm not going to, and I don't.
Sure, I mean, typically when you
So
put before.
it's not presented to us and hadn't been briefed.
Well, Your Honor, I mean, again, jurisdictional, this court can address it. You can affirm on any alternative ground
question
that's
about
in
that.
the record. And frankly, I think we did what litigants often do. They laid before the court the alternative bases for ruling in their favor. The court ruled in our favor on one or two bases, and it didn't have to address all of them. There's nothing unique about this proceeding. This is a very straightforward application of
No, but
arising.
usually the scenario would have been, when I was thinking about this brief, it would have been, the judge was right on the related to jurisdiction, but it would also be right to say arising in, and you all went right after the arising in, and
Your Honor, maybe we could have reordered the brief. We put forth both of the arguments. We think there's relating to jurisdiction for the reasons why the court said. We also think that there's arising in jurisdiction because this type of proceeding is unique to bankruptcy. To quote this court's decision in Bergstrom, it has no existence outside of the bankruptcy process. Its sole function is to prevent an end run around the 362A automatic stay, which is a bankruptcy-specific provision that finds no analog outside of the bankruptcy process. So it is a very straightforward application of arising in jurisdiction, which is why every bankruptcy court that has addressed the issue, we cite them at page 26 of our brief, has ruled in our favor, and that's certainly the case with respect to every bankruptcy court that has applied Fourth Circuit precedent. Just a couple of additional points, unless
That
there...
would be on a 105. That would be on a 105
Yes.
basis, not a 362 basis.
Yes, Your Honor. That would be, arising in is 105 in conjunction with 1334B. That's how this court
I
understood it
understand the
in Robbins.
claimant's argument that they disagree that 362 could apply to a party other than the actual debtor.
So what they're doing is disagreeing with A.H. Robbins, but A.H. Robbins made a couple of points clear. One, they said that you could apply 362A directly to a non-debtor if there was a unity of interest between the debtor and the non-debtor. We think we have that here, but you don't have to resolve that, because two, it also said you could reach the same...
You arguing that, what do they call, new Georgia Pacific and Bestwall are alter egos of one another?
No, Your Honor. We're saying that with respect to these claims, there's an identity of interest within the meaning of A.H. Robbins. But two, what we're also saying is that A.H. Robbins made clear you could reach the same result through a combination of jurisdiction under 1334B relating to arising in jurisdiction, and then the substantive authority under 105A to enter the injunction. And those two things can be used to essentially extend the 362A protection to non-debtors. It's not a direct application of 362A. It's an application of relating to and arising in jurisdiction combined with the court's equitable authority set forth in 105A. Here, we think this is a very straightforward application of arising in jurisdiction. It's also a straightforward application of relating to jurisdiction. I'm happy to answer any more questions on that, but I would like to briefly address two other issues that my friends raised. The first is their citation to the Arrow case. It explicitly rejected the application of Fourth Circuit precedent, and it involves separate and independent liability, not the type of derivative liability we have here. So Arrow simply has no application to a court that is applying Fourth Circuit jurisprudence, and under the Fourth Circuit's case law, this is a pretty straightforward case. Second, this so-called 1359 argument. The statute itself, 524G, specifically contemplates that there are going to be these types of pre-bankruptcy restructurings. What it says is that the 524G channeling injunction explicitly applies to third parties, quote, to the extent such alleged liability arises by reason of the third party's involvement in a transaction changing the corporate structure. So it specifically presupposes this. Put that to the side. Two other points on that.
Yeah, but
the first
you're not arguing that 524G bars a 1359 claim in all circumstances.
No, Your Honor, I wouldn't go that far, but that would lead me to my second and third points. The whole point of 1359 is that if you have a transaction, the sole function of which is to create jurisdiction, it has no economic purpose other than to create jurisdiction, generally diversity jurisdiction, then the court can look to that. Here, the purpose of the restructuring was not to create jurisdiction under 1334B. It was to facilitate the resolution of tens of thousands of asbestos claims pursuant to a 524G trust. That is a valid business purpose. Jurisdiction under 1334B or the other basis we cite is simply a downstream ancillary consequence of that legitimate business purpose. All of the cases they cite involve transactions that had no other economic substance than to create jurisdiction. We're at the polar opposite of that. And my final point on this is we didn't create jurisdiction. It already existed. I'll give you a hypothetical to prove my point. Suppose I've got a Montana company. I can sue a California company in diversity jurisdiction. I take that Montana company and I divide it into a Montana company and a Nebraska company. Now they can both sue the California company in diversity jurisdiction. I didn't create jurisdiction. It already existed. That's all that you have here. I'm happy to answer any further questions your honors have.
No. Fine.
Thank you very much, Mr. Francisco.
Thank you, Your Honor.
Let's see here. Ms. Ramsey?
Thank you, Your Honor. So our adversaries contend that the injunction and the restructuring is a good thing. And they talk about a permanent resolution and claimants getting paid 100%, but that's not what this appeal is about. We're arguing today that in the purview of a court of limited jurisdiction, the bankruptcy court has to stay within the strict parameters of law. And the law does not provide for a grant of nationwide injunctive relief for these non-debtors on this record. First of all, there are...
How many courts are enjoined from proceeding with cases?
I don't know how many courts either, Your Honor, but my understanding is that there were cases proceeding in almost every state court in the country at the time of the bankruptcy. Hundreds.
Would be, and would cases be also, some of them in the federal court system?
There were federal court cases as well. Fewer, but there were federal court cases.
But there are cases in the states and federal courts
That's correct, Your Honor.
that are, and they can't proceed.
And they cannot proceed.
Would there be cases in appeals courts of those states? And
There were also appeals.
they'd be
pending.
impacted as well, wouldn't they?
That they were, Your Honor. That is correct.
I mean, this is pretty broad. And how many, and you say 64,000 claimants, none of which can go to trial.
That's right, Your Honor, and none of which can go to trial in a circumstance where, and
Now, where does that fit in, all those numbers that I've pulled out here, into an analysis under Winter and our authorities for an injunction?
so with respect to, so first of all, our first argument
Number
is.
4, number 3, which were
Number 3 and 4, and 3 and 5.
3 and 4.
3 and
I'm
5.
helping you a little bit.
So the point is, in order for the court to act, it has to have subject matter jurisdiction. And the issue then, if you agree that the court had subject matter jurisdiction, which we don't concede, then the question is, does the court have authority? And then you get to the question of how the court evaluated the injunctive relief that it was entering. And there are two problems with that. One is the legal analysis of clear showing and not making a determination on the merits of the adversary action as opposed to a standard that really had nothing to do with the adversary action. And the second is whether 105 injunction can be issued in this circumstance. And the law is clear that 105 is not a roving equity. It has to be, it's not a remedy itself. It is designed to augment and protect other substantive rights in the code. And here, the court did not reach any of the other two statutory sections that were mentioned in the complaint itself, and therefore issued a 105 injunction without tethering it to any other provision of the code. And that also requires reversal with respect to its authority. I also want to hit, again, a rising in jurisdiction. Your Honor, to hold that a rising in jurisdiction could mean that any request for relief under Section 105, the court would have injunctive authority with respect to, would have subject matter jurisdiction over, extends 105 far beyond anything that has ever been seen in any of these cases. With respect to identity of interest, in the recent case in Patterson versus Mawa from the Eastern District of Virginia District Court, that court stated and relied on this court's decision in National Heritage Foundation that a court has to consider identity of interest. And identity of interest as interpreted in the case law is whether there's a obligation that would mean that a suit against the debtor risks depleting assets of the estate to the disadvantage of the other creditors. We don't have that here. The funding agreement completely insulates this debtor from any potential harm. And the notion that, again, that a party can come in ahead of time and say, we are conducting this divisive merger in order to provide the opportunity for Bestwall to go through a bankruptcy proceeding without putting the enterprise into bankruptcy, that entity can file 94 days later, and the documents were created before Bestwall ever existed. The plan of merger was created before it existed. The secondment agreement was created before it existed. It those documents had no business purpose.
But you can
They're-
raise all these claims at confirmation of the plan, that the plan is inadequate.
Your Honor, these are not claims that we're raising against the debtor. These are claims we're raising that
Right,
go
I
to the
understand
fundamental
that, but
foundation
you're-
of related to
Wait
jurisdiction.
a minute.
Sorry.
Your bottom line claim is that we want enough funds to pay all the claimants what they're due. So if the plan that's proposed, assuming that the lower courts are affirmed here, if the plan that's proposed doesn't do that, that they're not paid out to the full amount, then 75% of the claimants don't have to agree to it.
In the bankruptcy case, that is correct, but we believe that the problem with that analysis from our perspective is we don't believe that the bankruptcy court, whatever rights and that could be given to Bestwall, those rights cannot be extended to non-debtors who chose not to file their own bankruptcy under these facts. There simply is not related to jurisdiction. The structure does not ever limit the asset pool available for the reorganization or for the payment of creditors, so it doesn't impact the debtor.
Right,
Therefore,
but
there's no
nothing that
related
would
to.
happen here in this particular case is going to limit the amount of recovery to a claimant.
That's correct, Your Honor. And because of that, there is no related to jurisdiction, and these lawsuits should be able to proceed outside of bankruptcy. And getting past, again, related to jurisdiction, getting past the issues of creating jurisdiction, both crafting it under the common law in violation or in contradiction to this court's decisions, and other cases like Valley Historic, where the court has said the parties may want this and the intention for providing retention of jurisdiction may make sense to them, but you can't create jurisdiction in a federal court. It's a fundamental principle that the Supreme Court has articulated over and over again. So if you get past creation of jurisdiction under this and under the federal statute and related to jurisdiction, there is still the issue that the bankruptcy court did not apply the correct legal analysis by looking to success on the merits of a 524G injunction under these very unique facts and did not apply an analysis of other code sections upon which 105 injunction could be based.
Thank you very much.
Thank you, Your Honor, unless you have
Appreciate it.
questions. Thank you.
Mr. Herron?
Good morning again, Your Honors. I just have a few brief points. One, the references to A.H. Robbins. A.H. Robbins is completely distinguishable here. It's pre-Winter, pre-Real Truth. It's not 524G. It's not an asbestos case, so it's not subject to the specific provisions of 524G. And A.H. Robbins was the tortfeasor who manufactured and sold the Dalcon shields that were at the heart of the underlying tort litigation. In turning to 1359, it was in Ray Bishop where this court noted the general policy of viewing federal courts of limited jurisdiction where such subject matter jurisdiction should be applied with restraint. And we were careful here in how we phrased our argument. We're not challenging the underlying bankruptcy today. What we are challenging is the jurisdiction over the adversary proceeding, which is a civil action, which is within the meaning of 1359. And I'd like to address the hypothetical that my colleague posited about litigation in California and then a defendant in California that splits into Montana. Let's just move that around a little bit. Let's call it state court tort litigation in California. Let's pretend that Georgia Pacific is the defendant. And let's pretend that Georgia Pacific spins off Bestwall and puts it into Montana, incorporates it in Montana. And then Bestwall files a suit in district court, not in bankruptcy court, in Montana district court, seeking to remove the state court litigation against Georgia Pacific to Montana. We would assert under those facts, 1359 applies. Of course it does. That's exactly the type of manufacture of jurisdiction that the statute is intended to preclude. The only difference here is that after they incorporated Bestwall, they put it into bankruptcy. But it doesn't change the policy considerations underlying 1359. If they wanted to avail themselves of all the good things they're doing for claimants in the bankruptcy case, they could have put Georgia Pacific into bankruptcy. But by creating Bestwall, even if it's valid under state law, and using that as the vehicle, it implicates the Section 1359 analysis. And at a minimum, the bankruptcy court should have undertaken that analysis. Just two more quick points, Your Honor. I think the question that's kind of implicit, the issue that's implicit in many of the questions from the bench is what's the harm? What's the harm to claimants here? Well, it violates, it gives Koch Industries, Georgia Pacific's ultimate parent, improper leverage because it flips the statutory scheme imposed by Congress in 524G. Your Honors have mentioned the 75% vote. Under 524G, non-debtor co-defendants are only eligible for an injunction after the vote. The statute is very clear on that. And in fact, it says when claimants are asked to vote on the injunction, the vote solicitation materials must prominently identify that third parties are being protected by that injunction. So the 75% vote was supposed to occur before the injunction, not after. Here, a bankruptcy court, an Article I court, has issued an injunction nationwide of indefinite duration, staying the litigation against non-debtors of at least 64,000 claims. Now, non-debtor Georgia Pacific doesn't need to negotiate for an injunction before the vote. It has less incentive to agree to a fair amount of trust funding. It has little incentive to bring the Bestwall Chapter 11 case to a conclusion. When the actual debtor with the financial stake is in bankruptcy, the interest in getting out of bankruptcy are aligned with the claimants. That underlying principle of bankruptcy is absent here. That's one of the reasons the bankruptcy court imposed this injunction 5 years ago. And we're no closer to being done than we were on day one. Because the bankruptcy court flipped the statutory scheme, removed the incentive for Bestwall and Georgia Pacific to conclude bankruptcy. They're happy to keep us at bay. They starve the claimants of payments. They leverage them into voting on a plan that they otherwise wouldn't support. One last point, Your Honors. If this preliminary injunction is appropriate for Georgia Pacific on these facts, then in the Fourth Circuit, a preliminary injunction is available to literally any company willing to file a certificate of divisional merger with the Texas Secretary of State. Numerous companies have already done it in this circuit. Certainty created DBMP in Texas and then put it into bankruptcy in North Carolina. Train Technology created Aldrich Pumps in Texas and then put it into bankruptcy in North Carolina. Between those two cases, they've obtained preliminary injunctions to protect about 500 non-debtor co-defendants. And in the analysis where those courts cite back to Bestwall, they say that temporary injunctions in the Fourth Circuit are routine. I have nothing else, Your Honor, unless you have questions.
Thank you very much, sir. We appreciate it. Your appeal will be taken under advisement. I want to say that at this point, in the Fourth Circuit, the judges normally rise and go to the well of the court and greet the lawyers, shake their hands and thank them and tell you how much we appreciate your help. But we've suspended that procedure. And hopefully not in the near future, we'll change that rule back. But maybe next time we'll be able to do that, but we're not going to be able to do that with you today. But we appreciate your help. It's really good to have all of you here. And that said, Madam Clerk, we'll take a brief break.
This honorable court will take a brief recess. Honorable, the United States, the judges of the United States Court of Appeals for the Fourth Circuit. Judge King, I think the attorney from, okay, she's here.
You can be seated. Madam Clerk, you would call the next case for us?
We're ready to hear oral argument in case number 21-1207, Sackville versus Jadu.
Mr. Brannis? Did I mispronounce that? Brannius? Bannis. Good to have you with us, sir. You can take that mask off if you want to.
Yes, sir. Thank you, Your Honor.
Bannis, I've got to ask you a threshold question here, and that is, how does your client have any standing? He suffered no harm whatsoever. He has his H-1C visa. He's placed in another job, and even if he had received notice of the possible revocation of the H-1C visa in his previous place of employment, how would he be in a different position today?
Your Honor, I assume you're talking about Mr. Sackville, or are you talking about all of the plaintiffs?
I'm talking about Mr. Sackville, but I guess it would include all the plaintiffs in some respect, assuming they have standing at all. But let's just deal with Mr. Sackville.
Your Honor, Mr. Sackville has had to go through a second round of an H-1B lottery. He is preparing to go through, or he is going through the green card process, Your Honor, and one of the questions you have to answer on that form I-485 is whether you've had any petitions ever revoked or denied because of fraud, Your Honor. The agency will then go through his alien registration file and go do this entire analysis again when his green card's on the line, Your Honor. Further, if he travels out of the country and goes to the consulate, Your Honor, he'll be dealing with the Department of State's interpretation of this damaging material in his file, Your Honor. That's what we saw with Ms. Gadd.
But how does that affect his position today with his current employment, and he has his H-1C visa?
Your Honor, it is true right now that Mr. Sackville has an independent H-1B from the one that was tainted by the prior employer, his initial employer. And he is an applicant for adjustment of status, Your Honor. An adjustment of status is the functional equivalent of being, quote, vetted, Your Honor. And so it's not whether he's eligible. It's not whether he has, has the criteria to meet that particular immigrant visa.
Well, how was that issue before Judge Curie in South Carolina?
How was that issue?
Yes.
Your Honor, when we initially filed the case, all of the plaintiffs and the government admitted in its answer to the second amended complaint that all of the plaintiffs had been revoked on notice. That
You're talking about the 3 or the 17?
17, Your Honor.
You're talking about the 17 now?
Yes, Your Honor.
But you divided them into two different categories.
Right.
Your Honor, we're going into the 5th year of this case, so I think a little history will help. The first and second amended complaints, Your Honor, we allege that all 17 plaintiffs had been revoked on notice, meaning the agency had sent these notices of intent to revoke, they were all identical, to the office they knew was abandoned. When they got sent back, they revoked all of them without any notice. That's how they became my clients, Your Honor. They all of a sudden learned, after being in the country for a decade, they didn't have H-1Bs, and they had no idea.
14 of them got notices again,
Correct, Your Honor.
And then you've got the other 3 who the agency relied on the automatic revocation for fraud, correct?
Yes and no, Your Honor. They decided that these 3, even though they'd admitted that they had been revoked on notice, that they had been revoked automatically. When it's an automatic revocation under 8 CFR 212.4, what is it, H11.2, it's not for fraud, Your Honor. It's just because the
employer
closed.
withdrew the notice. Okay. So on those 3, the automatic revocation plaintiffs, go back to Judge Hudson's question. How are they injured now?
Yes, Your Honor. They were deprived of the cap-exempt status. I like that word the government uses, cap-exempt status.
Well, they got another visa that they've got now, right?
They've all gone through the H-1B lottery again. They've been lucky and gotten chosen again. Ms. Gadd was stranded in India for 4 months during administrative processing while the Department of State considered USCIS's fraud finding. Mr. Joshi was stuck in India for 3+ years until he could win the lottery again. And again, they're going to have to answer questions about this when they go to their interview for
But
the
what
green
relief
card.
did you want from the district court? What could
Yeah.
she have done?
Your Honor, she can set aside the agency's arbitrary determination that they were cap exempt, or their cap exempt status had been revoked. In the immigration system, Your Honor, when USCIS makes a decision, it all goes in the same pile called the alien registration file. And every time the agency adjudicates a new benefit, they go through the entire thing. Your Honor, all these benefits, adjustment of status, requires a clean past, consistent work authorization, consistent immigration status.
They all got visas again. That's when I'm having a real difficult time figuring out is what the injury. It seems like you're speculating that there's some possibility at some unknown time in the future something bad might happen to them. That doesn't give you jurisdiction. Doesn't give the court jurisdiction. That doesn't give you standing.
Well, Your Honor, let's be clear. At the beginning of this case in 2018, every single one of them had been revoked and they'd been told to leave the country in 30 days.
Yeah, well, that was then. This is now.
Okay,
Those
so-
three have got visas. They can't get anything better than that. How do they have standing?
Your Honor, they're going to have to deal with the stigma of this revocation during their next process that is pending. It's not speculative, Your Honor. My clients are going to their green card interviews. They're being harassed and questioned about these revocations, and no decisions are being made.
Well, they obviously were made in the past, or they wouldn't have the visas they got now.
They remain, I'm sorry.
Obviously, that was done in the past, or they wouldn't have the visas they've got now.
Your Honor, they have visas due to the exercise of discretion of the agency, and that is not something they can rely on going forward. And if they get denied a I-485 because of this implication, they have no ability to challenge that until they're put in deportation, and these folks will never be put in deportation because they have underlying non-immigrant status. They're going to remain permanent H-1B, which is the antithesis of what these statutes encourage, AC-21, ACWIA. They want to go from H-1B to green card. And this revocation done willy-nilly with no notice is going to harm them. It's harming them right now. They have no decisions. They've been waiting 2 and 3 years for their decisions on their adjustment of status applications.
But
They're terrified to travel.
But the possibility of revocation doesn't give them the kind of concrete harm that forms the basis of standing.
Your Honor, there's no possible revocation. They have suffered revocations here, Your Honor. Just because they've been able to change to a different benefit does not mean that those revocations do not harm them. These folks are now stigmatized by this fraud finding. And that's how these revocations have gone. The agency has revoked them by guilt by association, and that guilt is going to stay in their alien registration file, which does not leave them until they become a U.S. citizen. And when they apply to become a U.S. citizen, they're going to have to answer questions about this, Your Honor. A full and full-throated set aside of this revocation is the only remedy they have as they go forward through the immigration system, because they don't magically become citizens and not have to deal with the agency.
But how could that be the only remedy? I mean, if there's some adverse decision to them at some future time, they can bring a claim then.
They can't, Your Honor.
Why not?
The Supreme Court's decided in Patel v. Garland that this court does not have jurisdiction over denied I-485. And so if they get denied at the consulate, the Supreme Court has decided there's a doctrine of consular non-reviewability. They can't get reviewed. Mr. Joshi is a perfect example of that. He was traveling to see family when he found out he was revoked. When he went to his consular appointment to go get his routine stamp H-1B that he'd done 2 or 3 times, he found out he was revoked. He got stuck in the...
Hold on a second. Even if he couldn't challenge that, couldn't he go back at that time and make the challenge you're making now?
Challenging a revocation from 2012? No, Your Honor. I don't think so. 2018, right now, they're being harmed in a couple of different ways. They have applications that have been pending since 2016, that there is an injunction in place. That's why this case has gone on so long, frankly. There's an injunction in place that doesn't allow the agency to deny these things. It allows them to approve it. So if the agency was consistent in their position that these revocations that I challenged only related to the visa petition and not to the cap-exempt status, then there would be no barrier for them to be approving all of these things in the past, and frankly, these folks would have never hired me because they wouldn't have had to. But the fact is, with the 3 folks, the agency erred. They rejected it properly to get rid of the consequences for the employer, the petitioner, but they also rejected it for fraud under 8 U.S.C. 1184 G3. That says if there's a revocation for fraud, the cap-exempt number is also revoked, and it goes back to someone else from that particular petitioning year.
Right. let's set the 3 automatic revocation folks aside and go to the other 14. What's their claim in this case?
Your Honor, they have revocations from December 2019 that they are still suffering through. Some of them have been able to transition status to be derivatives of their spouses. That means their spouses had to go get an H-1B, then they had to get an H-4. And keep in mind, these things are not done overnight, so they have suffered different gaps in work authorization.
As I understand what the district court did, the district court said, well, look, under the rules, the claims of the 14 and the claims of the 3 are not the same. Adjudicating one isn't going to affect the other. So the 3 can go forward, but the 14 cannot. They have to go and make another claim, not in this suit. They have to file their own. And my understanding was some of them had done that. So the government raises that point, the Rule 20 analysis of the district court, which my recollection is you never responded to. So why is the district court wrong?
Your Honor, Rule 15 is the relevant rule for an amendment. We moved under Rule 15. The court held in its decision on page 245 of the record that our motion to amend, to have all 17 go forward, was timely, in good faith, not futile, and would not prejudice the defendant. That's the entire analysis under Rule 15. For 18 months, the client or the defendant and the court was perfectly fine with these 17 folks going on together. Their claims arise from an incredibly unique background, right? These are all victims of this guy from rural Virginia, Danville, who took advantage of 800 foreign nationals over a decade. That background is integral to framing their legally distinct issues, Your Honor. Our argument was that they had been riding together, they should continue to ride together, and that the differences in their legal arguments, first off, once the records were produced, given the government's admission that the 3 had been denied on notice, we expected to see notices, frankly, but we never got the records because we were challenging a different decision and they didn't provide a complete record.
What was the relevance here of the fact that the 14 were all from outside South Carolina?
Your Honor, there's no relevance to that. The standard under 281391E1A is that if it's a plaintiff, if venue is proper against a government entity, then it's proper for all. In this case, exemplifies why that's a good policy and why it's been the policy of the federal courts for 30 years. It only took one, instead of me filing 17 cases.
One of the 3 was from South Carolina.
Yes, Your Honor, Mr. Sackville.
And Judge Curry said these other 14 are completely different than the 3. So she rejected your effort to bring the 14 in.
Your Honor, she said it satisfies Rule 15, and for the first time ever when the government said it shouldn't be proper in their response to my motion to amend, she did make some findings in Rule 20. But she also said it was because they shouldn't be able to stay in South Carolina, that they needed better venue.
Tell us why this is what I asked you before. Why was the district court wrong under Rule 20? Because I don't think you ever addressed that.
Your Honor, if you look at our complaints, we make Rule 20 allegations sufficiently. And again, they have a shared...
Where in your briefing?
Your Honor, we didn't file a reply to the motion to amend. The court made big hay of that. Replies in the District of South Carolina are discouraged.
Your briefing in this court, the district court ruled on Rule 20. Have you raised that in this court as error?
No, Your Honor. We believe the court made a decision on Rule 15 because we moved to amend, and that's what we argued under, Your Honor. That's correct. And again, these 17 all have the same claim. The government admitted they were all revoked upon notice. When they decided to reopen after they lost the motion to dismiss, they decided to reopen everything and try again. All of a sudden, again, after more than a year of litigation, for the very first time ever, the government claimed that these 3 had been done on an automatic. However, the automatic revocations are arbitrary because they revoke the cap-exempt status of the 3 plaintiffs, and that's not an automatic revocation cannot do that. The government claims now in their most recent filings, no, of course not. That's not what happened. But if you look at the way they've been treated, it absolutely happened. They would not have been allowed to enter the H-1B lottery a second time and get a second cap H-1B if the first one hadn't been fully revoked. They would not have had problems traveling. Mr. Joshi would not have been stuck in India for 3 years. Ms. Gadd would not have been stuck there for 4 months, almost losing her job. The fact is, these revocations were done haphazardly to punish the victims of this H-1B fraud. They were already victimized, and now the agency is punishing them for that. And for that reason, Your Honor, we would ask that this court reverse and remand this case back to the district court. Thank you.
Thank you, sir. Ms. Molina, good to have you with us.
It's a pleasure to be here. Thank you. Good morning. Good morning, and may it please the court, Vanessa Molina, on behalf of U.S. Citizenship and Immigration Services. I would first like to address the dispositive issue in this case. Then I would like to address the issues that this court discussed today. This case, as the court raised or asked about, is about the fear that the appellants may be denied benefits or their green cards in the future. And appellants just conceded that, and I would like to refer the court to the argument in the motion to summary.
So are you talking about the 3 appellants that are automatic revocation appellants, or the other 14, or both?
No, Your Honor, I'm only talking about the 3. The
Okay.
certified administrative record relates to the 3. The 14 appellants, the only issue there is whether they were correctly dismissed in the analysis of joinder. The certified administrative record and the issue on the merits here, or jurisdiction now, only relates to the 3 that were revoked automatically. Again, to finish, the joint appendix in page 698, lines 11 to 22, again, that's where plaintiff appellants concede that this is about a future harm. And some of they also discuss that this harm will come when they are being adjudicated for their green card or legal permanent residence. We don't know when that will be, so we cannot, we don't even have a date on where that will be. As the plaintiffs also explained to the court, there's other reasons why those adjudications may take a long time. There's also a claim that Mr. Joshi was harmed by being in India, and Mr. Joshi, DHS records show that he's entered the United States in 2022. And so even if that harm was sufficient to confer standing, that issue has become moot. And if and when the green cards are being adjudicated, if they're denied, they can seek review of that. And even though Patel says they may not seek review in the district court, they can seek review through a petition for review directly to the corresponding court of appeals in this jurisdiction. So it is clear then that there's an agreement between all the parties that the harm may or may not occur during the adjudication of the green card petition. And at this point, it is impossible to know when that will happen because that relies on different circumstances.
So I take it your argument here is that none of the 3 have standing.
Correct, because
Therefore, we have no jurisdiction. Case is over.
Correct, Your Honor, that's dispositive because there is nothing that the court can do with the automatic revocations and taking them back. And that goes to my next point where the regulation calls for 3 occasions where there are automatic revocations, and including one where the employer would have to notify USCIS that it went out of business. There are 3 3 times where the regulations say you have to notify USCIS. Well, if you remove that one, which is when the employer has to notify USCIS that it terminated its employer-employee relationship, then the other ones would become superfluous. It wouldn't matter then that an employer would notify USCIS that it went out of business. But it is the regulatory command that employers are responsible for notifying USCIS. And because they can be penalized, say there's a site visit later on, USCIS conducts a site visit, and they don't find the employees that they requested. Because in order to bring employees to the United States, the employer must show that there's a need. So in that case, the employer would have problems. And I think I'm gonna go ahead and move forward with the other issues that this court raised. Another way to summarize this case is that
Why wouldn't you let them amend? You all, the government kind of took both sides of this thing, didn't they? Changed your position.
No, Your Honor. If you look at the second amended complaint on paragraph 80, the plaintiffs allege that all of the plaintiffs were revoked on notice. And if you looked at the government's answer also on paragraph 80, I'm sorry, it was paragraph 80, the government denied. There wasn't confusion because the government was responding to initially what the plaintiffs had alleged. Then through the compiling of the certified administrative record, then it came to be known that there were actually 2 classes. And it was actually plaintiffs who demarcated the 2 classes and acknowledged that these 2 classes of individuals, the 3 and the 14, fell under different regulatory schemes. So I think.
So the district court, as to the 14, as I understand the record, the district court ruled that the 14 could not go forward based on Rule 20. And as I understand opposing counsel's responses, they never challenged that ruling in this court.
Correct.
Is that your understanding?
That is my understanding. They challenged.
So
Rule
can we
15.
conclude from that they have waived a challenge to the district court's decision?
Correct, Your Honor. And as Your Honor noted before, they didn't challenge it in district court either. The government did argue that they did not, the 2 classes were different, and that those plaintiffs, the 14 plaintiffs, should go and file suit wherever venue was proper.
And you were saying there was improper joinder?
I'm sorry, improper joinder.
Improper joinder.
Because of the
They
different.
had two lawsuits, 2 types of lawsuits there, and the 14 were in one and 3 in another one.
Correct.
So
And-
they didn't have any South Carolina plaintiffs in the one anyway, in the 14.
I'm sorry, Your Honor.
Didn't have any South Carolina plaintiffs in the 14 group.
Correct.
So they're
And
going to have to go somewhere else.
as one did.
That's basically your position and the court's position, as it ended up.
Correct. And to illustrate that point, one of the
But
original.
we review that denial of that motion to amend for abuse of discretion, correct?
Correct. And it's, the district court relied, again, in its discretion, and it went both ways. In one occasion, it ruled for the plaintiff, and in this occasion, it ruled for the plaintiff because it relied that in its assurance that the 3 should move forward because the issues were very simple. And and this time it uses discretion for the same very reasons that the court just raised to deny the joinder of the plaintiffs. And so even if plaintiffs contend that they raised it under Rule 15 amendment, under Rule 21, the court can assess on its own sua sponte this the joinder issue. I would also like to make the record clear that the government doesn't have any notice that the plaintiffs were harassed. That was an allegation that was just brought, and I wasn't made aware of any harassment, and this is the first time it was raised. If the harassment would come from plaintiffs being waiting for the consulate in India, again, that issue is moot, and if it took long for them to get here, we would take into consideration the pandemic and how between 2020 and most recently, earlier this year, the pandemic has relaxed the issuance.
But those issues were never before the district court.
No, I'm just addressing it because there was a claim of harassment, so I don't understand. I just want to clear the record that I don't know what the harassment claim is, and so I can't defend it. There was no harassment as far as the government is concerned. And then implicit in one of the arguments that appellants are now raising in this argument is that the purported effect of this automatic revocation may also hurt them in a citizenship application. Well, if they get to citizenship, that means that they clear the LPR. So again, that supports the contention that they may or may not be hurt when the LPR adjudication takes place. And also, the automatic revocations were not for fraud. There's nowhere in the record that those were based on fraud. Those were based on the letters that are on the record where the employer notified USCIS of the demarcation of the employer-employee relationship. And nowhere in the revocations does it explain fraud, and that is different than the notice of revocation, that the notice of intent to deny based on the revocation, those NOIRs, as we call them, did explain the fraud, but not the automatic revocations. Those were based on the notice from the employer. Your Honor, at this point, the government would like to reiterate that there's no injury because there's no, and it can't be redressed. Therefore, the three plaintiffs do not have standing. If in a future time they are adversely affected during the LPR adjudication, then at that time they may have a claim before this court through a petition for review.
Thank you very much.
Thank you.
Mr. Banas?
Thank you, Your Honor. Just three very quick points. While we've been waiting for this appeal, me and Ms. Molina have talked various times because the agency's denied various benefits for these folks because these revocations are harmful to them for both the 3 and the 4. I focused on the folks who got stuck outside of the country, who lost their jobs, who couldn't pay their rent, who couldn't pay their car payments, who couldn't take care of their puppies, who were stuck in Arizona with their girlfriend because of these revocations. At the outset of this case, harm was crystal clear, and that's why the agency was willing to bend and give us an injunction that would prevent any adverse decisions based on this rationale going forward. That's the only reason we're still here today, Your Honor, because the moment that injunction is gone, all of those are going to get denied because we've seen a preview of it over the last year and a half. We've seen I-131s get denied because there was fraud somewhere, and it's going to continue. This idea that we can challenge the denial of an I-485 in this court is practically not accurate.
Why not?
because you have to get put in removal proceedings before you can bring a petition for review, and none of my clients are going to get put in removal proceedings because A, they don't meet the statutory and the regulatory and the policy criteria for that, and B, they have underlying non-immigrant status. They have H-1Bs. They're not deportable. And so this idea that if they get an I-485 denied, that they can challenge it in district court is just not true. And the district courts that are addressing Patel right now are saying no jurisdiction, no jurisdiction. And so this is our forum. You know, we challenged it as soon as we learned about the revocations 5 years ago. And they haven't been able to see the record and make their challenge yet. And I will say, we filed this case it was right around Thanksgiving of 2018. From that point forward, the agency never once challenged venue or joinder until they agreed and consented to a motion to amend and then changed their scope of consent. We did challenge the Rule 15 finding, Judge Agee. We did appeal it. We did raise it. We did say that my motion to amend, which was the relevant...
District court ruled under Rule 20.
Well, then
That's the pertinent question as to whether or not you raised a challenge to that ruling.
I disagree, Your Honor. I think the relevant question is I moved under Rule 15. The judge made a decision under Rule 15. If she used the idea of joinder to say, I don't want to exercise discretion, I would say that we said when a lower court finds that the proposed amendment is good faith, not futile, for proper reasons, not prejudicial, that should outweigh this idea of joinder.
Are you saying you can't have a Rule 15 and a Rule 20 in the same proceeding?
I think you can, Your Honor, but I think you would want to see the government move under Rule 20, do something with Rule 20. The government argued venue, Your Honor, so we argued venue. This idea that, again, we didn't file a reply should not be dispositive of any of this. Replies are discouraged in South Carolina. They're not required filings. And if the agency raised a new issue in its response, the government or the court should have given us an opportunity to respond, period, regardless of this reply.
Say replies are discouraged?
I believe so under the local rules,
Motions
Your
or
Honor.
what? I mean, the courts don't want to see reply briefs?
They don't, as I'm sure your clerks don't want to, they don't want to see.
Reply briefs. I really think that boils things down usually.
I don't disagree, Your Honor. However, replies are not required. A motion in response certainly is. And the last thing I will say, Your Honor, is this idea that the automatic revocations didn't do the two parts of it, right? The revocation of the employer's responsibilities. The employees are gone. We don't really care about them. But also the revocation of the cap-exempt status under 1184G3. The reason there's no evidence of that in the record is the record is fully incomplete to even do that analysis. They didn't include the porting documents. They didn't include how they treated those. And so the agency is intentionally limited its record and it's taking advantage of the incomplete record in front of this court and the last court. And for those reasons, this court should reverse and remand. Thank you, Your Honors.
Thank you, sir. Good to have you with us. And if we could do so, we can come down and greet you and shake hands, which is a time-tested procedure in this court. But we've suspended that because of the pandemic, and we'll do it next time when you come. So good to have you here. Ready, and then we'll call the final case.
Our final case this morning is 22-1264 Rogers versus Kijakazi.
Yes, Mr. Piemonte?
Piemonte, yes, sir, Your Honor. Pardon me.
Hope I didn't pronounce you too bad there. You may remove your mask, and we'll Good to have you here, and you may proceed with your argument, sir.
Thank you, Your Honor. May it please the court, George P. Monty, on behalf of the appellant Shanette Rogers. Your Honor, I would request of the court to retain 3 minutes for rebuttal. The ALJ failed to give substantial weight to Ms. Rogers' VA rating of 100% permanent and total disability in this case, and failed to give specific, valid, and persuasive reasons for doing so in accordance with this court's decision in Byrd. The Social Security Administration...
Why is Byrd still good law after the regulations changed?
I'm going to tell you exactly why it is, Your Honor, because, excuse me, Byrd didn't interpret the regulation. Byrd relied on established case law in this circuit as well as 9 other sister circuits. Every circuit except 2 have ruled that VA disability ratings are important information or important evidence. The other 2 haven't decided anything.
Before or after the regulation changed?
They're before. This has been decades. The Fourth Circuit goes back to Deloach in the 80s.
We can assume all that's correct, but then the regulation changed. And the general rule, I think, in that setting in administrative law is unless the court has determined that the statute unambiguously requires the consideration of the other agency decision, then whatever the agency is that's adopting the rule can go ahead and adopt the rule.
Well, what the regulation does, though, it prevents a meaningful judicial review because the Social Security Administration has said, sight unseen, that this evidence is neither valuable nor persuasive, yet this court in Byrd said the exact opposite.
That was beforehand, though.
That was before.
That was before the regulation. So the question is, which one controls our precedent or the Social Security Administration commissioner promulgating regulation?
I apologize.
They got to abide by their own regulations. And that's what the gentleman from the government's going to say.
That is what he's going to say, but
They're not going to follow our precedent anymore.
the agency does not mention how it
Didn't they say theirs was based on the statute? And they say ours is not.
correct, but what they've done is I don't want to. What they have said is they under 405G, this court has the right to, or has the duty and right to review agencies' decisions and
Take them into account.
take them into account to make sure that.
To me, that makes sense. I mean, this lady served in the military, and the military, the Veterans Administration found her to be disabled under their definition of disability, and now the Social Security Administration, when she applies for disability there, they say, we're not taking that into account because we don't do that. We changed the regs, and we had the right to power and the obligation to change the regs. Well, they don't give us any weight. They don't give the VA any weight. Now, you might have sympathy from me that VA rating or determination ought to carry some weight, but that's not the regulation. That's not what it is, and if the regulations are valid, they supersede the court decision. In which case, they don't have to.
Didn't
Give it
Judge
weight.
Watts' opinion in Woods v. Berryhill decide this issue?
No, the Woods talked about,
Let me read you what the footnote says there. For claims filed after March 27, 2017, which this is, ALJs must still consider the existence of disability decisions by other entities, which they did, any evidence underlying those decisions, which they did, but are no longer required to provide written analysis about how they consider the decisions from other government agencies. Doesn't that end your argument?
no, Your Honor, because that issue wasn't before that court. That's dicta. Now the issue is before this court. And what we've got,
That footnote, in your view, is just wrong.
I'm not saying it's wrong. I'm saying it's not determinative of this case. But
you could still win with an application of you could still say they erred in what they did. You just can't rely on our prior authority and the VA.
correct, and that's where I'm going to, we've got, because the ALJ's decision has to be based upon substantial evidence. So what you have is you have the VA looking at the exact same medical evidence that Social Security is looking at. The VA says, not only is she...
That doesn't carry any weight anymore.
No.
It's got to be looked at independently.
No, but
By the Social Security Administration.
as the district court pointed out,
You've only got a little over 5 minutes. Why don't you tell us why the residual function capacity finding is first not waived, which the government says it is, and then why it's wrong? Just move on from the VA, why don't you?
okay. Well, it's, the residual functional capacity, part of it, I was only prepared to speak on one of them today, but we've briefed several. But the one that stands out the most is the sporadic nature of Ms. Rogers' symptoms. She has PTSD. It's severe. The ALJ agreed that she has severe PTSD.
Before you get to the merits, the government says that the argument you make in this court on appeal is not the argument you made to the ALJ, and therefore you've waived it. First, tell us why the government's wrong there.
Well, because the arguments before the ALJ are not preclusive. It's not a preclusive finding, whatever's argued. What the district court and this court reviews is the evidence in the administrative record.
Are you saying that you get to make an argument on the evidence here for the first time that was never presented before?
No, Your Honor. What we're making here is about the residual functional capacity of Ms. Rogers. That is always an issue before the ALJ. The ALJ has to, excuse me, the ALJ has to make an assessment, given all of the evidence before them, what the claimant's residual functional capacity and ability to engage in work activity remains in light of their severe and non-severe impairments alone and in combination. So to say that issue wasn't raised is wrong. That's always an issue before an ALJ. And there's how the ALJ view or assesses the RFC is that's one of the issues that we've raised in the district court as well as this court, and one of which is the fact of the intermittency of her symptoms.
Why don't you tell us the best, say, two arguments where the ALJ got the residual function analysis wrong? What were your best arguments?
Okay, the first, I think, and best is there's ample evidence within the record that during Ms. Rogers' menstrual cycle, her symptoms are worse. That's documented throughout her medical record. The ALJ And this court has said that you have to take into account the fluctuation of a person's ability to function. But the ALJ said the RFC finding in this case was it's always the same. Every day, every week, every month. But that's not the case. During her menstrual cycle,
So is your argument that the ALJ didn't address that point?
Correct. He did not account for that period of her symptoms increasing in intensity, frequency, and duration.
And the commissioner admitted that the ALJ decision, as they put it, I think, is not a model of clarity. They said that.
Correct. And,
And they cited rules that were not applicable to her claim.
well, exactly. Going back to the VA, the ALJ didn't even rely on.
Which gives you an argument that they didn't understand, that the ALJ really didn't understand it.
Whether or not he understood
You
it,
have to deal with that. That's the point that you have to be arguing for her, and not this thing about the Bird case. I think you need to understand that.
the other RFC assessment, to get back to Your Honor's question on the two best, was the need for the therapy dog. That's documented in her medical record. There's a note from her doctor that it's the therapy dog is medically necessary. Yet there's no accommodation or discussion of the therapy dog in her RFC. So that hypothetical was never posed to a vocational expert. So it's, again, unknown. The ALJ in this case has left gaps in the RFC assessment, not allowing this court to do a meaningful review, leaving you to guess, because those questions were not presented to a vocational expert. So there's no evidence in the record on how or if or how those two things would affect a person's ability, Ms. Rogers' ability to work. I mean, on that, unless there's other questions, I'll reserve the rest of my time for rebuttal.
Thank you very much, sir. Mr. Mervis?
Thank you, and may it please the court. David Mervis on
Good to
behalf.
have you with us. You with the Social Security Administration?
Yes, sir.
And you're a Special Assistant United States Attorney?
Yes, sir.
For this case?
Yes, sir.
Good to have you here.
Attorney for the commissioner operating under the auspices of the U.S. Attorney's offices. So
Yes, go right ahead.
thank you. Without minimizing Ms. Rogers' history in this case, the ALJ thoroughly reviewed the evidence and explained why it supported a conclusion that Ms. Rogers could perform a range of work. That work ought to be simple, it ought to be low stress, and it ought to involve limited social interaction.
So what about, we'll just skip over the VA stuff, but what about the argument opposing counsel raises that the ALJ was presented with evidence that this lady's menstrual cycle caused a change in behavior over time, and they raised that issue, but I did not see that the ALJ's opinion addressed that. Why wouldn't that be sufficient to require the ALJ to redo this and explain that issue?
I'll respond to that in two ways. The first way, Your Honor, would be that the ALJ absolutely considered the longitudinal history here. So we've got months, about 18-month period that the ALJ was reviewing. So the ALJ goes from, in fact, from the alleged onset date was May 2018, but the ALJ even discussed evidence before that. Continues on through the date of the decision, which is December of 2019. So the ALJ is considering the entire period and does so with particularity, with discussing how Ms. Rogers did over the course of that period of time. Did worse in mid-2018 when she wasn't engaged in therapy, did better in 2019 when she re-engaged in therapy. There was improvement, as noted in the, I apologize. The computer's beeping. I apologize. Now, but the second thing I would...
I mean, if they've raised the issue that this lady's cycle affects her ability to function and therefore it is a factor to consider in a disability determination, isn't the ALJ required to say why that is or isn't accurate?
I don't believe so, Your Honor, in this particular case.
What are you arguing, a harmless error? What are you arguing?
Well, the primary...
You raised it, you ignore it. She raised it, you could ignore it.
She did tell providers that was part of what her symptoms were. But the treatment notes are what the ALJ notes and says that, well, what the ALJ discussing those treatment notes, the decision makes clear that that's not reflected in those treatment notes.
Does that directly affect her employability?
If she were incapacitated for 2 weeks out of the month, absolutely, Your Honor. But that's not...
Shouldn't that have been considered by the ALJ?
We'd argue that the ALJ did consider the entire record, didn't specifically mention that specific allegation. We're all on the same ground there. I will note that, again, the point here is that the ALJ considered how she did over the course of the entire 18 months and didn't treat every day or every note the same. There were fluctuations. It is absolutely true that the ALJ didn't specifically mention Ms. Rogers' menstrual cycle. I would say there are provisions that the commissioner, these are sub-regulatory, these are instructions to adjudicators, that if there is evidence in the record that may cause harm to an individual, the decision writers should take care with how they discuss that evidence. Now, again, the primary argument here is that the ALJ didn't miss any treatment notes and didn't miss any allegations. Ms. Rogers did better when she was engaged in therapy. That's what the treatment providers said. She did worse when she wasn't engaged in therapy. That's what the treatment providers said.
But if it wasn't mentioned, how do we know whether or not it was even considered?
Well, the ALJ did say that he considered all the evidence. We know that the ALJ isn't required to consider every single record. Now, if
But if it specifically bears on the ultimate decision, isn't he or she required to articulate those grounds?
If that, I guess the response to that, Your Honor, would be there's not a requirement that the ALJ address every single allegation, every single permutation. So there's of her symptomology. So she says a lot of things about her, the effects of this PTSD, and the ALJ considers how she does over the course of the period at issue. Ultimately, the ALJ finding is supported by these treatment notes. So her statements are, the ALJ does consider and says they're not entirely consistent with the evidence that I've got. Now, doesn't articulate every single statement that she made over the course of the record. That is true.
Well, let me ask you about in the plaintiff's memoranda in support of a motion for summary judgment on page 34 of the appendix, there's this statement describing the claimant here. She has her worst times. She said her worst times are during her monthly cycle. Her symptoms included, it explains what those are. Why isn't that sufficient to preserve that issue from your waiver argument?
I guess I understood what our waiver argument was, is that she didn't argue this rationale of improvement, that she, what Ms. Rogers has argued in district court was about opinion evidence and about the ALJ's assessment of that evidence. Now, if we're talking about a specific allegation, we didn't specifically argue that she didn't raise this argument. So our waiver argument pertained
Well, if we find that this argument would be sufficient to require the ALJ to reconsider the opinion and explain that, and I take it you're agreeing now there is no waiver as to this argument about her cycle, wouldn't that be sufficient in and of itself to send the case back?
If that were the court's holding, yes. On the other hand,
I mean, somebody's got to write this thing. Why don't you tell us why that's the wrong answer?
it's the wrong answer because, Your Honor, the ALJ considers the longitudinal history, it considers the treatment notes, and considers what she says about her functioning writ large. Now, one line in the ALJ's decision, which, as I've indicated, is something that is particularly sensitive to this individual, that the ALJ might well have had good reason to not specifically name in a decision. That's not a reason to send it back. What's a reason to send it back would be that there's no confidence that the ALJ considered Ms. Rogers' condition over the course of 18 months, as reflected both in her statements and in her treatment notes, and in the folks that took a look at this case. The state agency consultants took a look at this same evidence and gave in a finding, provided a finding that Ms. Rogers could indeed work. The ALJ considered that. The state agent, excuse me, those are the state agency consultants. The treatment notes from Ms. Rogers' therapists say that when she's engaged in therapy, when she's on medication, which the ALJ discusses, she does better. She is able to perform work at this reduced level, which we I think all agree is a lower level of work, or less stressful, less socially demanding than her previous work. So again, the ALJ considers all of this evidence and puts it into a decision that is supported by substantial evidence. There's not, if the, now,
But if
Judge King,
it wasn't discussed in the report, how do we know how much weight that ALJ gave it? I mean, how do we assess that?
Well, Your Honor, the ALJ doesn't give a specific amount of weight to one statement or a subjective description that Ms. Rogers alleges. The ALJ considers that amongst all the symptoms that she's alleges. She says, like I said, she has made numerous allegations about the effect on her. The ALJ says
the weight that was attached to that particular problem that she had, wouldn't that be critical to the final decision made by the ALJ as to whether she could work 100% capacity?
Respectfully, no, in the sense that the ALJ has to consider all the symptoms that or all her subjective statements about her symptoms. This is a generalized assessment, and there's not a requirement that the ALJ specifically name each and every allegation that she's made. That's administratively probably impossible. She said a lot of things about how how her PTSD affects her, and the ALJ considers them together and says these aren't entirely consistent with what I'm seeing in the treatment notes. What I'm seeing in the treatment notes don't reflect, well, today she's totally incapacitated, and the next time she's able to work. The treatment notes.
And if he had said that, that might bring it into this particular argument, but I don't think he did. Well, what about the argument for the service dog? I mean, if she's got to have a service dog in order to function, isn't that going to figure into what kind of employment she can have?
The ALJ did discuss the service dog. The ALJ says that she presented at the hearing with the service dog. That's not the same. I would posit that's not the same kind of factor. What the ALJ in the treatment.
I mean, he came up with a conclusion that she can do certain functions in the national economy in order to hold a job. And maybe at the end of the day that's correct. But if you go to an employment or to an employer, and in order for you to function in that job, you've got to bring this dog with you. Maybe the dog claim is bogus, maybe it's valid, don't know. There are going to be certain numbers of employers who are not going to want that in their employment space. I mean, wouldn't that be a factor they'd have to consider in making the final determination?
The employer, that is, Your Honor, or the ALJ?
The ALJ.
No, Your Honor. And the reason is that the ALJ wasn't presented with evidence that was necessary for her to work. She has a dog. What the treatment notes show, and This is at the sites here, 301, 310, is that she presented to her psychiatrist with a dog. She asked the psychiatrist to write her a note and say that this was a dog that helps me, that provides me with comfort. Fine. The psychiatrist writes that note. She comes and says, I want this to be a mobility service dog. The psychiatrist writes that note. That's not the same thing as an opinion that she is unable to work without that service dog. If that were an opinion that the ALJ had overlooked, then we'd be in a different situation. The ALJ doesn't have an opinion that she can't work without this service dog based on a doctor's assessment of her condition. This is simply the way that the doctor accommodated what she had asked for. And that's fine, but that's not something that the ALJ needed to account for in the residual functional capacity, didn't find that it was a work preclusive or a work relevant limitation because she simply doesn't need it to work. There's not evidence that she needs it to work.
So can you go back and tell us exactly what you say the claimant waived in terms of the arguments here? What exactly are the issues that you say are waived?
Yeah, the argument that Ms. Rogers had presented is that somehow the ALJ in this court was that the ALJ didn't adequately or incorrectly assess her longitudinal history. So as she got worse, as she got better, and that this quote rationale of improvement wasn't supportable. We argued, and as Judge Agee, you pointed out, that wasn't the argument she made in district court. So this rationale of improvement, it's a little different than this.
So she waived that? Is that what you're saying?
She waived that by not arguing that in district court, that she didn't present that argument in district court. What we're talking about here today is a little different, and it's about the effects of her statements, her subjective statements, as to the fluctuation month to month, week to week. That's different. So we didn't make the argument that that was waived. But as we've been discussing here today, the ALJ considered the evidence of Ms. Rogers' treatment. Those treating notes that the ALJ considered, and there's no argument that Ms. Rogers, that the ALJ somehow missed a treating note, missed an opinion, that would have resulted in a different outcome. We've simply got subjective statements that the ALJ did consider, though, as Judge Hudson, you noted, didn't specifically itemize every single statement that Ms. Rogers made. But that's simply not the standard. And what the ALJ did here provides a clear path to the conclusion that the ALJ reached.
My point was, nowhere in the report does it show how much weight the ALJ gave those specific conditions in making the final analysis.
And Your Honor, my response would be that there isn't a requirement that the ALJ give weight to each specific subjective statement that Ms. Rogers makes. If there were that requirement, this would be a different case. We'd have a different set of cases to apply. But under the standard here, which is that this court be able to discern the ALJ's reasoning, the district court, of course, concluded that it could. Our position, of course, is that the district court was correct and that this court should affirm. Thank you.
Thank you very much, sir. Commissioner Piemonte?
Just a couple of points that I'd like to clarify. Excuse me, I'm going to go backwards. When you were asking Mr. Mervis about the need for the therapy dog, he's relying on a standard that if I had raised it, he would argue against. He's saying the doctor never said she couldn't work without the dog. That's not for the doctor to decide. It's for the ALJ to decide based upon a review of all of the evidence, including vocational testimony, about whether or not the need for a therapy dog would affect the ability to work. He never asked the VE that question.
Well, did you ask it?
I didn't do the hearing, Your Honor. We didn't represent her in that hearing.
Well, did whoever represented her in the agency proceedings, Did they raise the issue of the therapy dog as a necessity for her work? And what was the evidence they used to base that argument upon?
I'm sorry, Your Honor, my computer's not cooperating. I was trying to pull it up. As I stand here today, I can't answer that question. I don't have an independent recollection of if that question was asked. But what I do know, and it's in the medical record from Dr. Christenberry, she states the therapy dog is necessary. It's medically necessary. That's no different than a cane or a walker or some other assistive device being medically necessary. It may or may not affect an abilities.
You see, that's in the record. The doctor said that the dog is medically necessary.
Correct. Yes.
The ALJ knew that.
Yes, that was before the ALJ. I can tell you it's Exhibit 6F. Unfortunately, like I said, my computer's not cooperating. I can't give you the
Well, I'm
page.
not there, sir. You go right ahead. You go right ahead. But don't tell us anymore that you're making excuses about it. You weren't representing her. You're the only one we have here. You are representing her, and you're responsible for all of it.
I am, Your Honor.
You're her lawyer.
And I apologize that I cannot answer that question about if that question was asked. I should be able to, and I apologize.
That doesn't go over very well.
As for the menstrual cycle, the medical record documents she has good days, but well, in her case, it's good weeks, bad weeks. She, in this court, has repeatedly stated in Monroe, in Mascio, in Woods, that the ALJ must draw a clear and logical bridge from the evidence before them to the RFC finding. And here there's evidence before this ALJ showing that there are periods of time when Ms. Rogers' functioning is worse than other times, yet the RFC assessment is that she's the same every day, every week, every month. And that's just not the case, and the medical evidence doesn't bear that out. And therefore, the RFC assessment is unexplained, and you can't properly review it because the ALJ didn't provide any explanation, as he is required to do, as to why he didn't have why he found that there was no reason to say that there was at one point she'd have this functioning, at another point she'd have another functioning. Unless there's other questions.
Thank you very much, sir.
Thank you.
We appreciate counsel's arguments. The case will be taken under advisement, and we hope to see you back. All the best to you. Madam Clerk, we will adjourn for the day.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.